To speak today about the detail of the legislation on the new foreshore and seabed legislation. At least I would if I could, because despite the government's intention— no, I haven't seen it, Mr Henare. Despite the government's intention to pass it by Christmas, as of today there is no draft bill in the public arena that I can speak on. It is, however, likely that it is a law which will give billions of dollars of minerals to a few select iwi. It is a bill that could quite likely limit free public access to the beaches, and I note, Mr Speaker, that despite many invitations to do so, neither the Prime Minister nor the Attorney-General will confirm in this House that the legislation will forbid charging for access to the beach. This will be upon us just in time for summer if National and the Māori Party have their way. It is incorrect, as the government claims, that the bill will restore the right to go to court to claim customary rights. Such rights were in fact preserved in the 2004 legislation. It is more correct to say that the proposed bill allows claims to the courts for greater ownership rights than were available under the 2004 legislation. It will also say, however, that iwi will be able to negotiate customary title with the government. This, Mr Speaker, is why many New Zealanders are gravely concerned. Just today, the Coastal Coalition, representing over 8,000 Kiwis, have started a billboard campaign highlighting their real fears of a New Zealand where people are excluded from the foreshore because they're not Māori, or for that matter, from the right iwi. Looking at this government's record of giving away rights to Māori covertly, it's no wonder people are frightened. Veto rights over the Waikato River, sneaking off to New York to sign a taxpayer-funded separate Maori governance that even Ms Clark's government wouldn't sign. The ACT Party shares those people's concerns, Mr Speaker. Once again, one group of New Zealanders are getting special rights over the rest. This is not what the Treaty of Waitangi intended, as can be seen by anyone reading it without a vested interest in distorting its meaning. In fact, it's not even what the decision in Attorney General versus Ngāti Apa, the case that started all this, said. Herein lies the problem, Mr Speaker, with letting governments do the job that are properly the role of the judiciary. Despite the claims of many, including my colleagues in the Māori Party, the Ngāti Apa verdict did not give the Māori the foreshore, merely the right to have their case heard in the Māori land court. The judges said in that case that the chances were slim, and they said, and I quote, "Any customary property in the areas vested seem unlikely to survive," close quote. That's a direct quote from the Ngāti Apa decision. Contrast that with what Attorney General Finlayson has been saying. 10% of the foreshore and seabed, he has said, is likely to end up in exclusive Māori hands, 2,000 kilometres of the coastline. He even touts the direct negotiation route as the better option. And why wouldn't iwi go the direct option? Mr Finlayson says that will, quote, negotiate a settlement outside the courts which will eliminate excessive cost or uncertainty. Well, Mr Speaker, if I was an iwi leader and wanted to get my hands on a whole lot of foreshore and minerals, I'd be a moron to go through the courts when I can negotiate with such an accommodating minister. Mr Finlayson concludes that if Mr Finlayson concludes that giving large tracts of 90-mile beach to the 5 iwi that make up the Te Hiku Forum will keep the Māori Party on side, no legal precedent will stop him from doing so. If the Prime Minister decides it'll be less strife to give Te Atiawa the 20 kilometres of foreshore and seabed in Taranaki that they're after, then what the courts say is immaterial. And if they succeed, who would blame the other 6 iwi with coastal boundaries in the region from having a go themselves? Mr Speaker, successive governments, both National and Labour, have shown that political expediency is far more important than what is right. Labour did this when they overreacted in 2004 to the Ngāti Apa decision, and National is doing it again now. The only place to determine those property rights, Mr Speaker, is the High Court. The ACT Party agrees everyone should have their day in court.
Members, the time for this debate has expired. Call on Government Order.